Specifically, the case law says...
Whoa. How the hell do you jump to that conclusion? So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly...
How long is that going to take you? If it's not going to be a lie, go for it.
Judge, respectfully...
No, you lied to me.
We're in Judge Simpson's courtroom, and an attorney shows up acting like he can win just by sounding confident. He lies to the judge like he thinks no one will notice. But Judge Simpson sees right through him. You can literally watch the moment the judge realizes the attorney is completely bluffing. It's messy, awkward, and honestly kind of funny.
Dwayne Wilson, sir, please stand and give your full and complete name for the record.
Dwayne Wilson.
Thank you.
Judge, if I may, very briefly.
All right.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, the sole basis that the people intend to introduce quote-unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge...
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that counsel is attempting to...
Well, then I'll let him finish, because I don't know. It did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says...
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position...
Does that case clearly apply to search warrants?
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martel.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to. Just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then
The attorney walks in acting smart, but the moment he talks, nothing adds up. He rambles, jumps around, and brings up search warrants that have nothing to do with this case. The judge keeps trying to understand, but the attorney can't explain anything clearly. When the judge asks how any of this relates, the attorney freezes and stumbles. He mentions cases he can't explain and facts he can't connect. Everyone in the courtroom starts wondering if he even looked at the right case file. Judge Simpson stays patient, but the attorney keeps bouncing between random points. It honestly feels like he made up his argument a few minutes before walking in. The judge finally tells him to file a proper written motion. The attorney can't even say how long that will take, so the judge takes a break. After the break, the judge comes back with receipts. Literally, he checked the records and found out the attorney lied about the judge handling a previous hearing. Another judge handled it, not Judge Simpson. The attorney also quoted a case, but skipped the part that proved him wrong. The attorney tries to talk his way out of it, but the judge stops him repeatedly. The judge even says it looks like the attorney is trying to get him removed from the case just to get a different judge. The attorney denies everything, but the judge isn't buying it. He gives him a deadline to file the motion and moves the hearing to another date. Final summary, even simpler. Nothing got solved in this hearing because the attorney wasn't honest and wasn't prepared. His lies didn't help his client at all. They only made things worse. Judge Simpson caught every mistake. Most judges would have shut this down instantly, but Simpson still allowed the attorney to submit his motion later. The sad part? It's the defendant who suffers the most from having a lawyer like this. So what do you think? Should the judge have decided right away, or was waiting the better choice?